Hello, my name is Jackie Denham and I'm an associate in the employment team at Field Seymour Park Solicitors in Reading. I'm delivering a series of 3 webinars about the General Data Protection Regulation and specifically how you can lawfully process employee data under that new regime. Now, this is the second part of those webinar series. The first part was an introduction to the GDPR. If you're interested in viewing that, you can see it on our website. This second part in the series will be looking at data subject rights, the new concept of accountability under the regulation, and then going on to look at why we need to be concerned about complying with our obligations, looking at enforcement, sanctions and remedies. So starting with data subject rights. Under the regulation, these are far more extensive and onerous than we might currently be aware of under the current Data Protection Act 1998. So the first right of data subjects is the right to access. Under the regulation, individuals will have the right to request a copy of all personal data held by them by an organisation, free of charge, within 1 month of their request. The only exception to this timeline is if the request is complex or numerous, in which case an organisation can potentially extend the deadline for responding up to a further 2 months, so 3 months in total. As yet, there is little guidance of when it may be reasonable to request an extension. In addition, an organisation can ask the individual to specify the scope of their request. However, in reality, that is still open for an individual to ask an organisation to provide copies of all personal data held by all individuals at the organisation since that individual started employment with them. If a request is manifestly unfounded or excessive in nature, the organisation will be able to charge a reasonable fee for responding. At the minute, there is no guidance as to what that reasonable fee might look like. However, the new Data Protection Bill, which is due to come into force, does allow the government to place a cap on what that reasonable fee might look like. So we'll have to watch this space on that one. It is also potentially open for an organisation to refuse to comply with a request at all, again if it's manifestly unfounded or excessive. However, our advice would always be for an organisation to comply to the extent possible or reasonable within the time period and to explain to an individual the scope of the search that they have carried out. It's also important to note that under the regulation, if a request has been made in an electronic format, the copies should be provided electronically, and where possible, it should be provided in a secure self-service system. Again, it remains to be seen how many organisations at the minute would be able to provide such information in a self-service system. The second data subject right is the right to rectification. If personal data held by an organisation is inaccurate or incomplete, an individual has the right to request that that organisation rectifies the data. And the organisation has 1 month in which to respond to that request. The right to erasure. If data is processed unlawfully by an organisation, or if it is processed based on consent and the individual has withdrawn their consent to the processing, or if there is no compelling reason for the processing at all, the individual has the right to request that their personal data be erased. The right to restriction. If an individual is contesting the accuracy of the personal data held by an organisation, they have the right to request that their processing of that data is restricted until that data is verified. Similarly, if the processing is carried out on the basis of the legitimate interests of a company, the individual is allowed to request that that processing is restricted if they challenge that the basis of the processing is outweighed by their own rights and freedoms. Also, if they are challenging that any of the processing is in fact unlawful, again, they can request that the processing is restricted until that challenge has received an outcome. The right to objection. If data is being processed on the basis of the lawful interests of a company or the basis of public interest, then the individual has the right to object to the processing, again on the basis that it is challenging and saying that their own rights and freedoms outweigh the legitimate interests of the company or the public interest. Data portability. Individuals have the right to obtain, move and transfer their personal data easily in a secure way in very limited circumstances. Now, in an employment context, which is what we're focusing on, this is unlikely to apply. It's more likely to apply, for example, where an individual is moving their bank account between providers. Withdrawal of consent. As I explained in part 1 of these webinars, for a consent to be validly given, they have to have the right to withdraw their consent easily at any time if the lawful basis for processing the information is relying on the individual's consent. Lodge a complaint. Put simply, an individual has the right to complain in the UK to our supervisory authority, the Information Commissioner's Office. The right not to be subject to automated processing. Now, in an employment context, it's probably unlikely that organisations ever rely on automated processing when processing employee data. But if they do, for example, have such a process in place that is likely to produce a legal or significant effect on the individual, that individual has the right to obtain human intervention into that process and to challenge the decision that's been made. Now, the main circumstance that I can foresee arising where this would be relevant in an employment context would be if an organisation has an automated system in place for sifting CVs in the event of a job application. Moving on to accountability. Now, the regulation has introduced a new concept of accountability, which means that not only do organisations have to comply with the obligations set out in the regulation, but they also have to be able to demonstrate that they comply with the regulation, which means they have to have a whole heap of documentation and evidence to support this. At the very least, they must be able to show what their data protection compliance programme is and what their privacy governance structure looks like, i.e. who's responsible for ensuring compliance across the organisation. There are specific requirements in the regulation about record keeping, and this depends on the number of employees within the organisation. If an organisation has less than 250 employees, it must maintain records of activities that could risk the rights and freedoms of individuals, or if they process any special categories of data, or if they process any data relating to criminal convictions or criminal offences. However, if the organisation has more than 250 employees, the obligations relating to record keeping are far more onerous. Such organisations must keep records of all data processing relating to personal data of its employees. That basically means that all the information that would need to be contained in a privacy notice that is given to employees and job applicants, and essentially means it needs to have records of what data it processes, where it's kept, how long it's kept for, how it's kept securely, who it's transferred to, and various other information listed in detail within the regulation. In addition, all organisations will have to keep records of any data breaches and of all remedial action taken. The regulation also introduces concepts of data protection by design and data protection by default. What this essentially means is that the organisation has to be able to show that they integrate data protection into their systems and product designs to ensure appropriate measures are in place to comply with their obligations under the regulations right from the outset of introducing a new system. In addition, their systems must be set up in a way that means that by default, data can only be processed to the extent absolutely necessary for the purposes for which it was obtained. Let's look at data protection officers. Now, the regulation specifies that certain organisations must have a data protection officer in place. That's if the processing is carried out by a public authority or public body, or if the organisation's core activities include regular and systematic monitoring of data subjects on a large scale, or large-scale processing of sensitive personal data, or data on an individual's criminal convictions or criminal offences. Obviously, it's open for an organisation to voluntarily employ a data protection officer, and in any event, an organisation will have to have clearly set out what its privacy governance structure looks like and who will be responsible for ensuring compliance with the requirements of the regulation. Impact assessments. In certain circumstances, organisations will have to be able to show evidence of specific impact assessments having been carried out. For example, when an organisation implements or changes a process, programme or system, or when they carry out automated processing, or when they process the special categories of data, or when they process information that is likely to have a high risk to the rights and freedoms of individuals. In all those circumstances, they must have carried out an impact assessment, and this must be documented and be available to show to the Information Commissioner's Office upon request. Notification of breaches. In the event that a breach is likely to result in the risk to the rights and freedoms of individuals, a data processor must inform the relevant data controller without undue delay of this breach. A data controller has an obligation to inform the supervisory authority, so in the UK the Information Commissioner's Office, without undue delay and in any event within 72 hours. They must of course also notify the relevant individuals of the breach. Cross-border transfers. Similar to under the current Data Protection Act 1998, organisations must ensure that there is an adequate level of protection in place before transferring data across borders. This means they must either ensure that the standard contractual clauses approved by the European Commission are in place between the two parties, or they have binding corporate rules in place, or that they have the explicit consent of the individual to the transfer, or that it is being transferred to a country which the European Commission has determined has adequate protection in place. And there's approximately 10 of those countries. So moving on to look at why we need to be complying with our obligations under the GDPR. So looking at enforcement, sanctions and remedies available. Now the ICO has a lot of powers under the regulation. For less serious breaches, it will be able to enforce a penalty against an organisation of up to €10 million or 2% of the organisation's total worldwide annual turnover for the previous financial year, whichever is the higher. For more serious breaches, they can enforce a penalty of up to €20 million or 4% of the total worldwide annual turnover for the previous financial year, whichever is the higher. Now, when looking at the level of penalty to enforce, they will be taking into consideration the nature of the breach, whether it was intentional, whether it was negligent, what mitigating actions the organisation has taken to try and reduce the impact of any breach, whether they have any previous infringements of the regulation, what measures they have put in place to try and keep the information secure, and what notifications have been given both to the Information Commission but also the relevant individuals impacted. It's also important to note that not only financial penalties can be imposed. The ICO will have very wide investigative, corrective and advisory powers. This means that they can request to have access to the data processed within an organisation. This means they can have access to your premises and to your equipment and to view the data processing in practice. They will be able to issue warnings and reprimands, and they can order compliance within a specified period of time. In addition, they will be able to impose limitations on your processing activities. This could include right up to a complete ban or suspension on your processing activities, which could cause companies great difficulties. It's also important for me to highlight that the individual impacted could also bring a private lawsuit for any damages they have suffered as a result of a breach. So that's the end of part 2 of my webinar series. This is obviously only a brief introductory summary to our obligations under the General Data Protection Regulation, and you should take legal advice on your own specific circumstances, particularly if you process personal data for other individuals other than employees, which may have other restrictions and obligations on them. I'd like to highlight that Field Seymour Parks and our employment team here carries out breakfast briefings regularly. We also can forward our monthly e-bulletins, which highlights different updates in employment law. And if you're interested in any of that, please feel free to email me and I can provide that information to you. Also, please get in touch if you've got any questions or feedback on our current seminar, or any suggestions for your future topics. You'll see my contact details there. And if you're interested in the follow-up to this series, part 3 will be practical suggestions as to what steps a company can take now in order to ensure it's in a really good place next year when the regulation comes into force.